Meeting to order and begin with introductions. Rod, let's start with you, please.
I guess we have to introduce. Rod Diaz, otolaryngologist, public board member.
Christy Cooper, Audiology board member.
Karen Chang, public member.
Marcia Raggio, audiologist, board member.
Dee Parker, speech language pathologist and board chair.
Paul Sanchez, board executive officer.
Kelsey Pruden, Department of Consumer Affairs, Office of Legal Affairs.
Amnon Shalev, hearing a dispenser, board member.
At this time, if any members of the audience would like to introduce themselves, please do so.
Brianne Humphreys, board operations manager.
Joe Bartlett, Hearing Healthcare Providers, California.
Carrie Bowers, CAA.
Okay, thank you.
Tanisha Grace, enforcement coordinator.
Heather Olivares, legislation and regulations for the board.
And thank you to you too. We'll move on to approval of the board minutes from November 29th and 30th, 2018. These. Are there any comments or corrections to the minutes? Hearing none, may I hear a motion to approve?
I move to accept the minutes as written.
Second.
Okay, it's been moved and seconded that the minutes be approved as read. We'll call the roll. Rod?
Yes.
Yes. Abstain?
Yes.
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 Approval of the minutes.
We'll just go down. We'll go ahead and go down the order of the agenda.
Okay, go. You're ready with that?
Yeah.
Okay. The next item is going to be discussion and possible action regarding regulation as a result of AB 2138.
Oh, I'm sorry. We have public comment for items on the agenda.
Oh, okay. I'll follow your directions. We'll back up. Are there any public comments for items that are not on the agenda? Okay, hearing none. Now we'll move on to item 4. Did you want to?
Yeah. At our last board meeting, we spoke about Assembly Bill 2138 regarding licensing boards and the denial of applications. Our board chair appointed a subcommittee to discuss this bill and the regulations that the board needed to explore, and Marcia Raggio and Debbie Snow worked with Heather Olivares, our new ledge analyst, and I'll let Heather go ahead and talk more about some of the outcomes of that meeting.
So AB 2138 was signed by Governor Brown last year and will become effective July 1, 2020. The reason we're talking about this now, however, is because we have a statutory requirement to have regulations in place by the effective date of the bill. I put in your packet a memo that has some additional background on the bill, as well as a copy of the legislation if you want to reference it, but we won't go into too much detail since I know you guys talked about it a lot last year as well. But I met with Dr. Raggio and Debbie Snow I had come up with several different proposals and different options of what direction we can go in with our regulations. And then I walked through those ideas and then came up with kind of some ideas of recommendations for a direction that the board can go in. So in your packet are two regulatory proposals. They're labeled option 1 and option 2. So I'll kind of go through the differences and then we can discuss any changes, or if you want to go in a different direction, we can talk about that as well. And then I'll discuss some of the risks of each option, and then ask Kelsey also, since she's here, if she wants to weigh in on any legal issues as well. So option 1.
Heather, excuse me, can we talk a little bit of background for the board members? Some of the stuff you covered in your discussion, just
Sure.
on the bill itself, just to make sure that everyone understands what we're talking about with the options.
Okay, sure. So you mean on what the law does
Yes.
in general? Okay, so AB 2138 amends various provisions of the Business and Professions Code related to a board's ability to deny a license based on a criminal conviction, and revises requirements related to the criteria of rehabilitation that boards must consider when evaluating the denial of an application, discipline of a licensee, a petition for reinstatement, or a petition for early termination or probation. So in your memo, on page 2, includes some information on when looking at a conviction or discipline, there's a new 7-year rule. And so the exceptions that are written into a law is if it's a serious felony or a registrable offense under penal code, which is where more of your sexual misconduct type related crimes would fall under that. And then if the applicant is presently incarcerated, there's an exception for that. And if they were incarcerated and released within the last 7 years, you can still look at that. But basically anything older than 7 years cannot be considered in the application process anymore unless it was very serious crime. In addition to that, when looking at substantially related criteria, the board, the only thing that the law lists is looking at the nature and gravity of the offense, the number of years that have passed since the date of the offense, and the nature and duties of the profession in which the applicant seeks licensure or in which the licensee is licensed. And then the final step in reviewing these types of applicants and licensees, when looking at rehabilitation, the law states looking at the applicant or licensee completed the applicable criminal sentence without a violation of parole or probation, and the board finds after applying its rehabilitation criteria that the applicant is rehabilitated. So that is from the law. Now in option 1 of the draft regulatory proposals, what we looked at is crimes that are substantially related to the profession, and we chose to make a list of crimes that we feel are professionally related or crimes that our enforcement staff have seen when they're reviewing applicants or for licensees, and we added them into this list. So we can go ahead and look at in option 1, which is back behind a blue sheet of paper after the law, we came up with crimes substantially related that are fiscal or commercial dishonesty, fraud, deceit, or corruption related to money, items, documents, or personal information. And I just wanted to add that we did reach out to our DAG to also get information from her on crimes that they see, and that was her suggestion to add in commercial crimes. So that would include, like, I believe, Medi-Cal fraud and that type of thing.
And that's our Deputy Attorney General liaison.
Yes. And then we also added conviction or act involving grand theft or embezzlement, conviction or act involving child abuse, conviction or act regarding elder abuse, and conviction requiring a person to register as a sex offender, conviction or act involving lewd conduct or sexual impropriety, conviction or act involving assault, battery, or other violence, and conviction or act involving the use of drugs or alcohol to an extent or in a manner dangerous to the individual or the public. So the reason we are proposing this or recommending this option 1 is because if a situation needs to go through the legal process that the board has, like an applicant is trying to appeal a decision that was made to deny licensure, we can say, well, look, we listed out in our regulations crimes that we feel are related to the profession. Your crime fell within this. Therefore, we're making a determination in our regulatory process that this is substantially related. The other option, when we get to option 2, does not include a list of crimes, and that way a case can be on a case-by-case basis. But the risk with that is there may be more litigation involved, potentially.
Just want to point out too, with the first option, a risk involved in having a list is if a crime occurs that is not on that list, more litigation wouldn't be necessary as well, because the board has established set crimes. Not to say that it could not be enforced against, but that it would entail more work.
Can we do in option 1, give the list, but say, but not limited to?
I believe it, yeah, it already does
She
say,
does say
but
that.
are
So
not
it will
limited
cover
to.
both ends. We will still be able to litigate even if it's not on the list.
Yeah, so I'm talking from a practical litigation standpoint. So yes, absolutely, that is what the language says currently, and it does allow for that list to be non-exhaustive. However, if the board does establish a set of crimes, it's a lot easier to litigate those crimes than one that is not on the list. So,
Yeah, so.
but yes, it absolutely can litigate it. Yes.
Yeah, so we will have some occasions that will not do litigation because
The applicant will see it's on the list, I'm not gonna even dispute it.
Well, and I think also it's not necessarily whether they dispute or not, because anyone has a legal right to dispute whatever they want to dispute. But as far as what's the probability of it going in our favor versus not in our favor based on what's listed.
So this is what your DAG liaison or the DAGs assigned to your cases do. But in the instance where you have an applicant who has committed one of the crimes that is on your list, in the accusation or statement of issues, the statement of issues against that potential licensee, the DAG would list that regulation section and point to that specific crime. So whatever it may be, subsection B, for example, and rely on that, and then plead up the facts that surround that crime that is listed out. when you don't have it in the list, the DAG will still point to the regulation, but there will need to be a lot more facts and a lot more proving up, if you will, of those facts to show that it's substantially related, and there will need to be an argument as to why it's substantially related, whereas the argument is that the board has established that it's substantially related through its regulation if it's on the list.
So before I move on, is there any questions on the list we've developed or anything you feel should be added to the list?
I have a question not relating to the list, but relating to this law. Is where in the we have here the law itself, right?
Mm-hmm.
What section, which page it says that we should not ask for criminal past? Is there
On the application?
Yes.
It
where?
is,
I want to read the language.
sorry. Because this isn't the version that I'm used to, but I will find it for you and I will let you know.
Yeah.
As soon as I find it. I don't want to.
Because I want to know, I don't feel comfortable, but it's already become a law not to ask, but I want to see the language. Maybe we can put something in the regulation that, because I don't know why is the legislature said you don't ask the applicant if he is a child molester.
Okay, it's on page 93,
Yeah,
or page 93, yeah, at the top.
Section
Section 2,
Section 2 of,
at the
where's
top,
two?
except as provided in paragraph 1, a board shall
How
not.
come, are you on 93 here? And where do you see section 2? How come I don't see it?
Oh,
There's two different 93s?
oh, there are,
Whoa.
that's all 93, sorry.
Oh, yeah, there's two 93s,
I'm
so
sorry,
it's page
6,
2?
it's page 6,
It's page,
6.
page 6. Oh, everything is 93.
Yeah, everything's 93.
Yeah, okay.
It's all in 93.
Yeah,
Why can't you find it on 93?
Okay, 2, except as provided in paragraph 1. A board shall know. What's the exception, do you know?
So you can,
Except is provided in paragraph 1. A board issue.
you may require applicants for licensure to disclose criminal conviction history on an application for licensure. So it's different boards, and your board is not under these chapters.
Oh, I see. A board, okay. A board issuing license pursuant to chapter 3, and these are different boards? Do you know what kind of boards, why
I can
they are?
look, I can look.
They are keep asking people, and we are not.
I do not know, but I can look in the ledge history, and we don't have the internet right now, and I might actually have it on my computer. I might be able to pull it up. Let me check. But I don't know off the top of my head which entities those are, which boards those are.
I have a question. What other crimes that are not listed here, just out of curiosity, like that we did not list here, what other crimes do you think can potentially?
There's a ton of crimes.
Yeah,
I don't know. I think this is the challenge with making a list is you could go on for pages and
Right.
pages and pages of crimes because penal code is huge. But we wanted to try to cover ones that we see, our enforcement staff see, so we know that our licensing base would fit within these that we're listing.
Is it any crime or is it like just misdemeanors?
No, any.
Any crime?
Yeah, you can,
And
we can list.
So again, it has to be a crime that's substantially related. So what that means is that you have to be able to tie it back and make an argument that the underlying conduct of the crime or the crime itself is such that it affects that person's
Ability
to practice.
Okay.
So right now, there is some case law on certain crimes that does say it's substantially related, and a DUI is probably the one that's cited the most because that's the most controversial one in some people's opinions. But, so to answer your question, yes, it could be any crime. It could be a felony or a misdemeanor.
Okay.
However, it just has to have that justification that it is substantially related to the qualifications of the licensure.
Okay, so just to clarify in layman's terms, so if, say, somebody created a crime of, let's say, robbing a house, and it was 7 years ago, then they do not have to put it on the application.
Even if they made it a year ago, they don't.
Yeah.
Right. So,
even if they
so
did
the
it.
Yes, that's the
application,
problem.
the application now, you cannot, as of July 1st, 2020, the board will not be able to, as we call it, have a check the box. There's no question that asks about criminal convictions. There's no place for someone to say, yes, I have been convicted of a crime. Let me give you a brief synopsis of it. However, so practically speaking, then what happens is they still have to be fingerprinted if they are requesting, or if they want licensure, so they have to be fingerprinted. And so DOJ will send, I believe it's, does DOJ send the report?
Yes.
Department of Justice will send the report to the board saying this person has these crimes or this crime, whatever it is, based on the fingerprint. Then it'll be upon the board to notify the applicant that they are aware of this crime that falls within, if it's past 7 years for a robbery, for example, and it's not one of the substantially related crimes, then the board's just going to say thank you and not do anything with it. Mm-hmm. However, if it is one of the substantially related crimes and it is within that 7-year period, or if it is one of the serious felony crimes, then the board will be asking that applicant for mitigating factors and evidence of rehabilitation, and then making a determination on the application based on that information. But as it stands now, the applicant has the opportunity to check the box, yes, I've been convicted of a crime, and then give sort of a story of that, and provide that to the board, and that will no longer be the case.
Okay, so the board will only know that a crime has occurred after they've been fingerprinted.
Yes.
And they get the license before the fingerprinting?
No.
No.
Okay.
No.
After that.
I guess unless the applicant gives that information to the board voluntarily, the board will not know, right, until they're fingerprinted.
Yeah, so in the current setting, we ask them the question and we fingerprint them, and we don't give them a license until they have cleared those processes,
Okay.
meaning to the satisfaction of our staff, they are clear to be licensed. In the future, when this has been implemented, it will be based on the information we get from their fingerprints.
Okay.
I know we cannot change the law right now, but I'm extremely disturbed by this. I don't trust the government, us included, to be able to screen everybody on the fingerprint. There were the last few years, 2 mass shootings where the people purchased legally guns, the dealer ran an FBI and got the wrong results, and the people got the guns. Now, what's happened if we don't ask and the patient doesn't say, and he has few DUI recently in another state, and whatever happened to the system, we didn't get it through the fingerprint. And 3 years later, we found out, and he has no problem, for 3 years practice here perfectly. 3 years later, we found out that he has a DUI. So what do you come tell him? Give me your license, you have DUI, I've done, I'm perfect, you know, I've done. In the old system, when the person checked, I didn't have it, you can come after 3 years and say you lied. Here we cannot do it. He didn't lie. That's a problem.
actually, yeah, my other question, do you guys check, when you do the fingerprinting, is it for the entire United States or only for the state of California?
We do for the state, and we do Department of Justice and FBI.
Oh, okay.
And what, I just, I know we got to get back to the language, and what Amnon is pointing out, I think is a valid concern. Just for your knowledge, there are times where we don't see crimes reported through the fingerprint process even. We fingerprint them, we run it through the database, and we find out from the applicant that they committed a crime. I don't have an explanation for that, but we know that that has happened, and other boards have reported the same. One of the reasons for this, in the Little Hoover Commission report, they did point out that in many cases, someone maybe for whatever reason was confused about the application or forgot that they had a conviction, and then they were being disciplined or denied by the board for not disclosing, and they saw that as a problem and as a barrier.
What I was going to say, I don't believe that it's in the language here. There, well, no, it's not. I know that it's not. Sorry. So that portion of the law that I was reading about how the board cannot ask for any information or documentation regarding the applicant's criminal history. It does say, however, a board may request mitigating information from an applicant regarding the applicant's criminal history for purposes of determining substantial relation or demonstrating evidence of rehabilitation, provided that applicant is informed that disclosure is voluntary and that the applicant's decision not to disclose any information shall not be a factor in a board's decision to grant or deny an application for licensure. There is the potential to have this on your application as a voluntary information gathering. I think the wording would have to be very carefully crafted, and that's not what we're dealing with today, but that is something we can look to in the future.
I want to ask you, the language you said that a board shall not require to disclose, applicant to disclose. Does it really strictly say the board you are not allowed to ask, or is there a way that we still ask?
So I think applications are generally done by regulation, which is makes it a requirement. I do see a way to maybe have some voluntary information gathering on to determine substantial relationship or rehabilitation, but I do read it as saying that the board should not ask, and I think to be in compliance with the spirit of the law, it would be risky for the board to have the question posed as a permissive question, if you will.
But what is the incentive for an applicant to voluntarily give information that he does not have to give? Because I think if he gives information that he does not have to give, we should deny him the application based on stupidity.
So I don't know that the law would allow you to deny based on stupidity. However, I think that the incentive is that if you can show rehabilitation, the board may grant you a license. So you might be willing to offer up the reasons behind the conviction and what you've done since then to show that you are capable of holding a professional license. So it might be in the best interest of the applicant to provide that to the board so that the board can weigh that as evidence when making their determination.
But I understand the applicant has always the chance to show rehabilitation after the board will come and say, hey, we found that 2 years ago you have this violation. And he would say, oh, okay, I've done this and this and this.
So and that's a good question, and I can brainstorm with Heather some more on what to do in those situations, and that's probably a really great question for your DAG liaison as to how that they would handle that. An applicant who was granted a license because the fingerprinting was not accurately done, and what to do.
Is there a possible, I don't know if it be in this section of the regulation or another section that we write that says should the board find that something like 3 years down the line, we find that this person, this applicant actually did do one of these crimes that we listed, is the board allowed to reconsider the license?
You mean as in taking it away?
Or just relook at it, you know?
Yeah.
Potentially.
Yeah, right?
If it was issued by mistake,
Yes.
there is recourse for that, yes.
So in here or there's someplace else?
It's existing law. Mhm.
Okay.
Do you know, Kelsey, by any chance, which other healing health boards are also should not ask for prior convictions?
It's I think almost all of the healing arts boards. I think the only ones in DC.
I believe it's accountancy that is exempted, and I want to say funeral and cemetery or professional physician.
I can look it up. I just don't have the internet currently, so.
Funeral, cemetery licenses have to, the board will ask for prior conviction?
There are several boards that were exempted, listed in the statute. I do not believe any of them were healing arts boards. I believe they are other boards within DCA, but not within, any boards that see patients.
Is the medical board?
This applies to
This
the
applies to
board.
them, yes.
Not, also cannot ask?
Right.
Yes.
So if you want to be a physician, assistant physician, or whatever, you're not allowed to ask for prior conviction?
Yeah, there were only a handful of boards that were exempted, and none of them are related to healing arts. Any other questions specifically related to this list?
Yeah, can I ask, is there any other crime that we think might belong on this list that we haven't identified? That's probably one of the most important things we could look at right now.
That's what I was thinking, like, is there anything else here that we haven't thought about? I mean, the major crimes, right?
Well, major crimes aren't even subject to the 7-year limitation anyway, so we're covered on huge things like murder, rape, that type of thing.
Arson,
No,
home robberies.
I mean, if you feel like we should add that, definitely we can. If
What do
someone
you
wants
guys,
to.
this is just the top of my head.
Just think that not limited to.
Yeah, not limited to.
Right.
Takes that into account.
Right, I mean, we could definitely have like 20 pages.
Yeah.
And we don't want to go down that, because we also, when we write up our initial statement of reasons, and this goes through the regulatory process, which will be subject to public comment, we have to justify every single thing, how we're determining that is substantially related as well, so.
I think not limited to is fine.
Where does it say that, by the way?
The not limited to, that's in section C.
Right above the list of crimes.
And I think from a practical standpoint, this is a starting point. There is going to, I personally think that there's going to be a lot more that the board will need to do as a result of 2138. So I think that this is our starting point. We're going to try and get these regulations in place when the law becomes effective, so that you, as a board, can continue to license and can continue to deny licenses. So I think that I just want the board to be aware that this isn't the end-all, be-all. There will be other opportunities to revisit and to see how it evolves after we put this in place and after applications start coming in and start being denied.
And then this will go through the public commentary process as well. So the public is welcome to weigh in on things they think should be added, or if they want to make an argument that something shouldn't be on the list. Like, this is totally a public process with opportunity and encouragement to weigh in. So is there any other questions on this list piece specifically before I go on? Okay. So the next section is criteria for rehabilitation, denials, and reinstatements. And what was added here is what's required by the law is looking at the nature and gravity of the crimes, the length of the applicable parole or probation period, the extent to which applicable parole or probation period was shortened or lengthened, and the reasons behind that, the terms or conditions of parole or probation and the extent to which they bear on the applicant's rehabilitation, and the extent to which the terms or conditions of parole or probation were modified and the reasons for modification. So then, after going through all that, if that is not applicable, or the board determines that the applicant did not make the showing of rehabilitation based on the criteria in subdivision A, the board shall apply the following criteria in evaluating an applicant's rehabilitation. The board shall find that the applicant made a showing of rehabilitation and is presently eligible for a license after considering the following criteria. If after considering the following criteria, the board finds the applicant is rehabilitated. And so this gives the board opportunity to look at the nature and severity of the crime, evidence, the time that has elapsed since the crime, the extent to which the applicant has complied with parole or probation, and then the criteria in subdivision A 1 through 5 as applicable, and evidence, if any, of rehabilitation submitted by the applicant. So the way this is written is we can ask the applicant to submit their own information on their own behalf as well, whether they want that to be letters of reference or maybe community service, or something that shows they took their crime seriously and tried to improve their life after that. So you'll see that that repeats itself in the next section as well. There's a lot of repetition, and that is because since we have the regulations for speech language pathologists / audiologists, and then a separate hearing aid dispensers is in a separate section. So it's the same info we included in both, but because of the way our regulations are written, we had to make changes in 2 different sets of codes. Is there any questions on that? Yeah.
I was just wondering if evidence or presentation of contrition is considered rehabilitation.
Of what?
Contrition, if they apologize, if they recognize the error of their ways, so to speak, is that considered rehabilitation?
Well, I think that would be, the way this is written is it gives you discretion as a board to decide whether or not you would want to consider that. So, I mean, when they present their information to us, whatever they want to present, you guys or board staff would be able to look at it and then make a determination of what they think.
I think that, again, it's a case-by-case basis, but yes, that could be considered as a part of rehabilitation. I think that there are lots of different ways to show rehabilitation. And as you know from the discipline cases, there are many ways, right? References, character references, community service, contrition, right? If you have somebody who is not sorry and writes a letter saying such, that the board will take that into consideration, whether or not that person is really rehabilitated. Because if they don't have contrition, are they rehabilitated?
Okay.
Do they see that what they did was wrong and have grown from it?
And then I think you could also take in consideration to the absence of such information as well. Like, did they choose not to speak on their behalf? And what does that say, in your opinion, on whether or not they are rehabilitated? So it can go either way. Any other questions? Any other questions? No? So the next section on suspensions and revocations is just the same as that. And then we move into, in the substantial relationship criteria and the rehabilitation criteria, it's all just the same. It's the repetition because of the way our codes are written. So if you guys don't have any other questions on that, we can move on to option 2 and see how that's different. So in option 2 for the substantial relationship criteria, the way the direction we went for this was to not have a list. And so this is the option where the board can decide on a case-by-case basis whether they want to consider something substantially related. But then, as Kelsey mentioned, that's where it's really more broad for the litigation process. It's possible the board could see more denials going into litigation if the board just decided, because let's say for applicant A, you decided this crime is substantially related, but for applicant B, you didn't. It could get to be more of a sticky point. It's just a risk. But then the opposite side is it gives you broad discretion. So this is another option that the board can choose to go. Is there any questions about that? Okay. So then the criteria for rehabilitation in this option is if subdivision A, I'll just read subdivision A. When considering the denial of a license or a temporary license or the reinstatement of a license on the ground that the applicant was convicted of a crime, the board shall find that the applicant made a showing of rehabilitation and is presently eligible for a license if the applicant completed the criminal sentence at issue without a violation of parole or probation. If subdivision A is inapplicable, the board shall apply the following criteria in evaluating an applicant's rehabilitation. The board shall find that the applicant made a showing of rehabilitation and is presently eligible for a license if, after considering the following criteria, the board finds the applicant is rehabilitated. And so then that criteria is the nature and severity of the crime, evidence of the crime, the time that has elapsed, the extent to which the applicant has completed parole or probation, and again, evidence of rehabilitation submitted by the applicant. So the way this is different is in subsection A, basically if they completed their criminal sentence, that's rehabilitation. So is there any questions on that?
In most of the violations that come in front of the board, the licensees we ask for revoke the license, but we put it back and we give them 3 years, let's say, probation. Is it possible here when an applicant that we find out a year ago has a couple of DUIs can get the license but right away be placed on probation?
I am not sure about that.
I'm not sure I understand the question.
The question is like this: if applicant come and we find out that he had a DUI recently, a couple of them.
Prior to being licensed?
Yeah, prior to being licensed, because we know licensee can have a DUI,
Right.
Then we put him on probation. Can a new applicant can get the application approved but being placed right away for 3 years probation? Is there such a thing here in our
As opposed to going
Before we deny it.
Well, so that process wouldn't change. When we find out that they have convictions
Yes.
that are cause for denial, we would go through the
Yeah.
process of denying. We deny the application, and then the applicant has an opportunity to appeal. If the applicant appeals, then we send it over to the AG's office to write a statement of
Yeah.
issues. And then they have to respond to the statement of issues. And that's what starts the process.
I see. So it's possible. There's a mechanic for this.
Yeah,
For an applicant.
That would not change.
Did it happen here? I mean, the applicant was denied from getting a license and then gone through a hearing, and then we placed him on a probation?
Well, typically,
applicant.
what you see are applicants that have either gone through a hearing
Yeah.
or have settled prior to going through a hearing.
Okay.
But if I'm understanding you correctly, you're asking whether we'll still be able to do this when
Yeah.
this law is in effect.
Right.
And the answer would be yes, that process would not change.
Unless it was a crime that could not be considered.
Yes.
Right.
Any other questions? Okay, so again, what you'll see in the following pages is just the repetition again. So it's all the same for if you are interested in option 1 or option 2, it'll just be the same throughout for both the hearing aid dispenser sections and the SLP audiologist sections.
You know, we've talked a lot about litigation, and I just want to make something clear that when we have cause for denial and we file a statement of issues against a licensee or against an applicant who we've denied, it's meant to go through an adjudication process. So it's meant to go through the hearing process. I think what Kelsey was pointing out is in the charging document, the attorney that represents us, what we refer to as the DAG, the Deputy Attorney General, is going to cite the codes that we approve if we approve specific crimes. And that makes it easier because that person says there's cause for denial based on they committed this crime in California Code of Regulations such and such. If we don't cite something specifically, then they have to tell why it's related, right? Why it's substantially related to the profession that they're applying for. But in both cases, we are going through the adjudication process. We just want to we want to have a strong case, and we want this to be something that's, easy to prove. We don't want to make it more complicated than what it needs to be.
And that's not to say that somebody couldn't legally question whether or not one of these enumerated crimes is substantially related, just because the board says it is and has gone through the regulation process. That doesn't mean that it can't be questioned. Like I said, there are court cases, and the one that comes to mind the most is on DUIs. And there is court cases to support that, yes, it is substantially related. So I just want the board to be aware that your DAG still will have to charge up and argue that this is a substantially related crime. They will just be able to point specifically to the code section that says so and not have to make quite as eloquent of an argument.
And typically an applicant is arguing their rehabilitation efforts and why they should be licensed. That's typically what we see and what you will see in the discipline cases that you have. It's usually not, although I agree with what Kelsey's saying, but it's usually not, this isn't substantially related. They're saying, yes, I know it was convicted, but I should be licensed because.
And in that case, option 1 is what gives you more stuff to look at in that case. So, is there any other questions? Any preferences board members have for one option versus the other, or concerns?
I prefer option 1.
Yeah.
Any motion?
Yeah, any motion?
Any motion to approve the regulation language and
Or any
designate,
changes
delegate
that-
to the executive officer the authority to make any non-substantial
Write
changes.
down up.
And well, actually, I'm going to take that back. I think that you should delegate to the executive officer the authority to make any changes consistent with board policy, especially since the board will have the opportunity to see the language before it becomes final. But in the meantime, if there is some sort of hiccup along the way, and the language needs to be changed, but we understand the board policy as it was discussed today, then delegating to the executive officer to make those changes consistent with board policy.
Yeah, I move to approve option 1 with the changes that you mentioned.
Is there a second?
I second.
Any discussion?
Can I ask a question? I don't know if this is kosher, but Debbie called me and wanted to vote, and I'm not sure if that's allowed.
No.
Okay.
But that is very sweet of her to ask.
No discussion, any comments?
Oh, we need to ask for public, right?
Yes, any comments from the public? Okay. Then let's call for the vote. Ron?
Yes.
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 Passes. Thank you for doing that.
Committee and Heather, they did a great job.
Yeah, and Heather.
And Kelsey.
Thank you,
helped us, too.
Kelsey. And you'll take it from here.
You guys ready for the next item? Or
Yes.
Did you want a break? You're good? Okay. So the next item is RPE direct monitoring requirements and telesupervision. The board has seen these regulations before. They were actually approved by the board in August 2018. However, this has been a priority I've been working on in getting these through the public comment process, and in doing so, Kelsey discovered that we did not define direct supervision and telesupervision. So
Well, I think we were relying upon another regulation package, and that is too risky to do. So,
well, and that one's not in place yet.
Yeah.
So I'm working on this one ahead of the other one, and so it would leave a huge hole to not define these terms. And also, I made some changes to improve the readability as well for when telesupervision can be used. And then also the definitions that I came up with for direct supervision and telesupervision are loosely based on what was decided for the SLIPA supervision regulations. Those went into more detail on specific things that can be done within that. But this one is more, I didn't go into like this task and that task, but it's based loosely on that. So if you guys want to turn to the actual regulatory language, the definition that I came up with for direct supervision means in-person, real-time, personal observation and guidance by the RP supervisor of activities related to the field for which licensure is sought, performed by the RPE temporary license holder. Telesupervision means real-time personal observation and guidance through electronic means by the RPE supervisor of activities related to the field for which licensure is sought, performed by the RPE temporary license holder. Is there any questions?
Do we have to stipulate any time element to that? Like 100% of the time, or is
Well,
it?
we
is
get
that
into
implied?
that in the next section. We get into how many hours that has to be for that telesupervision can be used.
So it's not appropriate to put it in there?
I mean, I could, but Kelsey, do you think we would need to?
and so you're asking like for individual activities, or, so I think the way if we ended on that was that it's up to the supervisor to determine what's appropriate to be done via telesupervision. So if you have an RPE and you're not comfortable with them performing a certain function without you being physically present in the room, then telesupervision is not appropriate. And then I think we listed out a couple of other areas where it could be appropriate, but we do limit the number of hours per month that telesupervision can occur.
What I'm thinking of is, in a given therapy session, for example, where there is telesupervision, does the supervisor have to observe for half the time, a quarter of the time, all the time?
So I think that it could be done in a number of ways, and what I'm about to say is consistent with the board policy, then it could be that, and I don't know about what it looks like to supervise an RPE, so excuse me if I get any of the sort of facts wrong, but so if I'm supervising an RPE and we have a 2-hour block one day where I'm supervising these functions, I guess it could be that for a portion of the time I'm telesupervising because I'm comfortable with the functions that the RPE is going to perform and the patient has consented, etc. But I might supervise the latter portion in person because it either has to be or I'm not comfortable with that outcome. But I don't know that the board, in discussing this, limited whether or not the full session had to be in person or whether or not you could break it up. But I think the point being that you could break it up as long as it doesn't exceed 4 hours per month.
I can just imagine a situation where they wouldn't necessarily want to break it up and come personally to watch the second half, but rather questions would arise to how much, if I'm not concerned, everything's going well, even if it's a very serious matter, it's my opinion that I don't have to watch all the time. People are going to wonder, they're going to ask, how much do I have to be there?
Okay, so, but currently, if you are supervising an RPE, you do have to be there 100% of the time. So I think what the board policy was, if I understand it correctly, is that it's consistent with that, but that you are able to do it for no more than 4 hours per month in a telesupervision setting. So I think it still has to be 100%. If the board policy changes on that, then we can definitely change the language to make that clear.
Yeah, do we have to reference that?
Well, and it says personal observation. So are you saying like they would have whatever electronic equipment they're watching, but they're over here on their computer doing something else?
Not necessarily, just that they're not physically watching all that time. They've watched for 30 minutes and feel it's going well. They don't need to watch for 60, even though the session is for 60 minutes. Mm-hmm. But they have that discretion.
I don't think that the regulation reads how it's written now that they have that discretion, because they don't have that discretion when they are in person.
Right, so I think so long as there's some language that references that,
okay. To make it very, very clear? Okay, so
maybe adding something after personal
I think that's what we remember. When we talked about this, we talked about personal observation meaning exactly that.
Right.
I'm not quibbling over that, it's just how much of that time has to be. I made the case before what I'm trying to say.
Sure.
I can just see people asking about it.
So in 1399153.3 on the next page, when it's listing the supervisor's responsibilities, it says under subsection C, ensuring that such supervision consists of direct supervision for a minimum of 8 hours per month for each full-time RPE. And then so I'm wondering if we put it in this portion. Okay. I'm seeing another issue, hold on.
Like maybe adding after the 8 hours per month of personal observation, or in, or, I don't know how to.
That still doesn't get at it.
Right, how to say, of your undivided attention.
Well, so we're saying telesupervision may be an appropriate form of direct supervision if it meets the following requirement. So if the board chooses to have to have the person monitoring that person 100% of the time, then I think we need to say it there, that it's an appropriate form if they're actually monitoring the person 100% of the time. Is that what we're saying, Marcia?
If that's what the existing regulations say, for a regular RP, not a telesupervision. I mean, well, I don't know if we can't just reference that.
So I don't think it, as it reads right now, it doesn't have that very direct language that you're referencing. But I think that we can definitely craft it so that it's consistent for both direct and telesupervision. That it is 100% of, and maybe I'm having it. What would be the word for this? Is it a session? Is it a?
Typically.
It's called a session?
I had written down,
okay.
it'd be the same.
Okay, so for the entirety of the session, right? Or something like that? Would that be an accurate?
Or just, is there a way to say that the supervisor will comply with regulations as in this section?
So it's the same section. What we're just saying is that you always had to directly monitor, but now, as a part of direct monitoring, you can telemonitor or telesupervise.
Okay.
But they are the same. The telesupervision is whittled down a little bit in the sense that you can't do it for the same amount of hours. Plus, you have to check all these boxes of the patient has to consent and be aware, the same standard of care. But I think that I hear what you're saying, and I think that adding that supervision must be for the duration or entirety of the session, and that would apply to both direct and telesupervision. And I think that probably might go in, it can go in a number of places. It can go in responsibility of the RP supervisor. We could make it a part of the definition. And that's something that I think that if the board likes this policy and putting this language in, we can delegate that to the executive officer, and Heather and I will work it in to the regulation.
What I wanted was that it was going to be the same.
Right, okay, so consistent between the two.
Yes.
The two types of supervision, and it needs to be for the entirety or duration, or essentially 100% of the time that the RPE is with the patient. Okay.
I like 100%.
Very direct, 100% of the
There
time
it is.
that the RPE is with the patient, or
So
some
I wanna
other
ask for clarification. So a moment ago when you said there are times where you might be with an extern or something for a portion of the appointment and then they're good and you might leave, would that be considered indirect supervision or like 30 minutes of direct supervision?
Yeah, something,
'Cause
one of those.
Okay, so if we're specifying 8 hours per month of direct supervision, and then we're also adding this direct supervision for the entirety of the appointment, that's going to prevent us from being able to say, okay, well, 30 minutes, I've sat through the case history, looked at otoscopy, we've started pure tones, they're good, I'll be in this room. So I think half of the appointment is direct and the other half would be indirect.
If we can't, if she's saying that the normal RP supervision is direct 100% of the time, this can't be different.
Yeah. But what, if I'm hearing this correctly though, so if in that situation though, you're there for a half hour, so that would be a half hour of direct supervision, right?
Yes.
So it wouldn't be the
And then it
entirety
accumulates
of
to
the
8
appointment,
hours
but it
per month.
also, it wouldn't, it wouldn't be an hour, so you'd still have 7.5 hours for that month that you would have to directly supervise.
Correct. So I'm thinking of it as it's written currently, it being like the cumulative. So I know I need to provide 8 hours of direct supervision, but if I mean, it may not always be during
The entirety of the session. It might be that you're giving 8 hours, but it's in 30-minute increments for the start of the session or the end of the session or somewhere in between, but you are meeting that 8-hour threshold. It just might be a multitude of sessions.
So my next question was going to be,
I'm
okay.
lost now.
All right.
If we can say it's okay to have 30 minutes,
Yeah,
keeping
so
your 8 hours in mind, and then the other 30 minutes, you don't have to supervise them at all, or you have to be in the building,
Indirect.
or...
but in that circumstance, you're no longer supervising. So it's not that you have to supervise for, there's no requirement that you supervise for the entirety of the session.
Okay,
But
so
there is
that's
a
what I thought
requirement.
you were saying, but in the normal RPE supervision, face-to-face or in the same, it does say that, so it doesn't. Is that what you're saying?
No.
No, it says 8 hours per month.
Right, so, so I guess,
So,
so if you are supervising, it does have to be for 100% of the time. But when you only do 30 minutes of the session, you are only supervising for 30 minutes.
And it's okay. It's
Yes.
okay to do
As long
that.
as you're getting your 8 hours per month.
Yes.
And to me, this is how it reads that way. If we add
Yes.
the other, then I just have concerns.
But if you are supervising, you are supervising. You cannot, so to your question, I think where I got a little confused, if you are supervising, you are there in the room and you are directly observing. It's not that you can be supervising from the other room, or you can be supervising by doing other things, and count that towards your 8 hours. If you are supervising, then you are doing it for the entirety of that time that you have towards your 8 hours, I guess.
So do we need to say anything about it, or is it already
So
off?
so now we're back to the definition of direct supervision.
Well, actually, I think we're back to the definition of telesupervision.
Right, but first, just to, because I think that's where some of the confusion was. First, the direct supervision requirement is 8 hours per month. And what we're saying is, of this direct, you can do telesupervision for 4 hours of those 8, right? So then, I think we want to make sure that we're all on the same page as far as what direct supervision is. What Kelsey just identified was the definition you came up with, means in-person, real-time, personal observation and guidance by the RP supervisor of activities related to the field for which licensure is sought, performed by the RP temporary license holder. So telesupervision has to fall within that at a minimum, right? And then you define further what telesupervision means.
Yeah, so I think maybe we need to add something in telesupervision that says, kind of, you're not distracted, but in a nice way.
I think that, I mean, you definitely can add the language, but I think that they are consistent. You can only do 4 hours, and if you are doing those 4 hours, or you're doing only 1 hour, whatever it may be, you are telesupervising for that entirety. So if you have worked it out with your RP that you are going to telesupervise them for 4 hours per month, going towards their 8 hours, then those 4 hours that you telesupervise, you are directly observing them. And it might be in a half-hour increment, it might be in a full session increment. I don't understand the logistics of that because I've never gone through it. But so it doesn't have to be the whole session, but it is consistent with what direct monitoring is as well.
Consistent.
Right.
Okay.
So if you are counting it towards that hour or half hour or whatever, you are directly monitoring, whether it be in person or electronically.
Could you define a tele or electronic means? I mean, are they all, Skype or Zoom
Well,
or something?
so
Could it be a phone conversation?
So it should say
Yeah.
video.
Well, so this is a challenge in regulations is if you define a specific means, I feel like there's a little bit of challenges with that because then you're telling somebody exactly how they have to do it. Like you have to do it with Skype, and then you're ignoring FaceTime on the
But
iPhone.
should we
I
say
do
something
think that
broader
there
from the
should-
standpoint of video?
Right.
Yeah.
Because the whole point is that you're actually watching, so it should be
Right.
electronic video
And that is.
monitoring.
'Cause you
And
have
they can do
someone on
Skype, they can do
speakerphone, just
FaceTime, they can do whatever.
That's exactly the problem, Paul.
Yeah, I get it, yeah.
So you want to change means to electronic video monitoring?
Yes.
Okay.
Or something like that.
Yeah, I started researching some different means, and there's some systems out there that can cost thousands of dollars, where it makes you kind of feel like in a virtual reality type, like the person is really right there. And you don't want to go down that path saying it has to be this kind of system and excluding all other kinds of systems.
Well, I think part of my concern is I have had students come back and say that they were supervised in this manner, but the person wasn't always paying attention to them or wasn't always in the room, but they count that time. And maybe you've seen the same thing, you're nodding your head. And this is the students were worried, did I do it correctly, or they had questions, and when the person wasn't in the room, they couldn't really respond to what they had said. If the person's in the room the entire time, you know. If it's part-time, even if the person leaves the room and they're face-to-face. But I just would like to see this the same requirement. And you're going for it, thank you.
Well, I mean, we could add something in the definition of telesupervision that says, like, with your full...
You know, we could add there too, Heather, is visual observation, so that we could leave it as electronic means, but make sure that it's visual.
In both
Yes.
cases, so you actually have eyes on the person.
Okay,
Yeah.
thank you, Paul. That's it, yeah.
And I think that the board would, if there was somebody who was, you know, not supervising, I think on a case-by-case basis, the board would be able to bring action against that person to say you were not actually supervising. So I think that we do want to be very clear, but not whittle it down so much that, you know, it's too challenging to do, right? Because what is undivided attention mean, or what is, you know, that's fairly subjective. So I think we would have a problem with getting the regs through. But I think adding some language like visual, I think that Heather and I understand what the board is saying, and so again, consistent with the policy of the board that if you're saying it's supervision, eyes on the person, you're directly there, you're either in the room or you're watching them by electronic means, and that can be for 30 minutes, it can be for an hour, but whatever it is that you're counting towards supervision needs to be eyes on the person. Am I understanding it correctly? Okay.
At our university, we have a way of, each faculty member has a monitor in their office, and they can watch 4 students at once. Oh, wow. For obvious reasons. And so they have four clinics going, four students. So that would be kind of unacceptable in this model, because you wouldn't certainly have eyes on just one of those students for 30 minutes. You're flitting from one to the other, kind of make sure it's all going well. And so that's not going to be okay anymore.
Right, so I think that this is the question to the board. What is acceptable? What is the acceptable form of supervision?
So that brings up the difference between what could be called direct versus immediate.
Yes. Yeah.
I didn't want to bring it up.
But we knew it was there.
It's always the elephant in the room, right?
Another cat.
Yes. Yes.
Any other questions on the definitions?
So I think we need to flesh out Marcia's question a little bit. I mean, do you feel that that is adequate supervision?
Yeah, if you're going to add that, if you're watching.
Oh, I'm talking about the 4 monitors.
Oh, it sounds like that's going to be not acceptable once this goes.
Well, I mean,
I think what she's asking is a 4-monitor situation acceptable to the board?
Yeah, it's more that. I would say it's more is it acceptable to the board?
I'd have a problem.
Yeah,
I would have a problem.
it's not the best way to do things.
It's
just
not
it's
really
just more
attending.
efficient.
And if you're going, do you zero in on 10 minutes at a time, or are you going 5, 5, 5, 5? You're missing the entire session, or can you go back? Is it recorded and they could watch it?
You probably have that capability to
If it's recorded and they have the ability to watch the entire session or whatever time frame.
Yeah, are they going to?
well, and I guess if you had the ability to know how much time you spent watching each individual, right? If there was some way to say that you watch student A for 15 minutes, you watch student B for 12 minutes, you watch student C for 15 minutes, whatever, and then you only use that increment for the amount of time that you actually supervise that person.
I have one of the older setups, so if I want to watch somebody, I have to push a button to watch that room, and then this button to watch that room. So I really can't watch all
You can't watch
at the
all.
same time.
Okay.
So I could monitor how much time I spent with each one.
But it's still not in person.
No, they're down the hall.
Are you guys ready to go on to the changes in the responsibilities of RPs?
Hold on, I think I have a
I'm
question.
just wondering, how many hours are they supposed to fulfill?
Yeah, it's
We've got clock hours.
the clock hour, it ends up at 350 or something like that.
350 hours?
It's 50 at 3 sites, a minimum of 3. So you have to be in a clinic, in a school, and on campus.
Okay, so in terms of this, like looking at 4 monitors, we also have to look at it in a capacity standpoint. Are there enough people?
Oh, this one is only 8 hours.
Okay.
This is only 8 hours per month.
Okay. And that so they do these 8 hours per month, and that's their.
I suspect they do more, but that's all they have to do, a minimum of that.
Okay.
But so if they did more, then you could do your 4 monitor situation. If you've
So
exceeded
if you
the time.
just jot down what you're doing.
Okay. So on the next page, the responsibilities of RP supervisors. As we already mentioned, supervision consists of direct supervision for a minimum of 8 hours per month for each full-time RPE and 4 hours per month for a part-time RPE. Telesupervision of the RPE temporary license holder may be an appropriate form of direct supervision if it meets all of the following requirements. Telesupervision is limited to no more than 4 hours per month for each full-time RPE and 2 hours per month for part-time RPE. The RPE supervisor informs the patient about the use of telesupervision and obtains verbal or written consent from the patient for the use of telesupervision, and the consent shall be documented by the RPE supervisor. The same standard of care is exercised when providing telesupervision as when providing any other mode of supervision. And the RPE supervisor evaluates the functions to be performed by the RPE temporary license holder while telesupervision will occur, and based on the RPE supervisor's professional judgment of the individual RPE temporary license holder's ability, the RPE supervisor determines that there is no need to be physically present with, sorry, it's hard to read in black and white, with the RPE temporary license holder for this direct supervision. Then E, the RPE supervisor evaluates the functions that the RPE supervisor may need to demonstrate while telesupervision will occur, and based on the RPE supervisor's professional judgment of the individual RPE temporary license holder's ability, the RPE supervisor determines that there is no need to be physically present with the RPE temporary license holder for this direct supervision. And F, the RPE temporary license holder is physically present with the patient while being telesupervised by the RPE supervisor. Any questions about that or needed changes?
Do you have to have video to add to every statement where you say telesupervision, or just?
Well, I think if we define it, whenever we use
we
the
don't have
word,
to
Yeah,
yeah.
if we add it to the definition. And I think to sort of piggyback on what we were talking about earlier about it being consistent, it's all direct monitoring, but telesupervision is a form of direct monitoring. So that's sort of how we've laid it out, that you need to directly supervise, and this is a format in which you may do so for no more than 4 hours per month. So you are directly supervising, you're just doing it by video, electronic means.
Do we have to justify that? Why it's 4 hours and not 5?
Yes, actually we do. So we had a discussion about it at the last board meeting. If I remember correctly, ASHA standards or CASHA standards are different in terms of the RPE monitoring, so we didn't have a really great sort of example to look at. But I think the board determined that half of the time was an appropriate amount, but I will surely invite more discussion as to it, because that is going to be something that needs to be justified in the initial statement of reasons. And so having any input on why the board chose that number would be very helpful to Heather and myself.
I'm just curious, does the VA operate under different rules than, because they're a federal agency or something, than, because they've been
So
doing,
yes, they can have different requirements.
Yeah, they've been doing telesupervision for a decade already.
And I actually, off the top of my head, I don't know this board, but I know for a lot of other boards, you don't need a license requirement sometimes for the VA, and so it's a
Yeah.
so there are different standards.
Yeah.
But if that is something that you think we should look at in determining maybe how many hours are appropriate.
I don't have any idea if they have any rules about it.
Oh, okay.
They might. I doubt it. I don't know.
Does the board feel that half of the hours is an appropriate standard? I don't know how much of this, I don't know it from a practical standpoint, right? So I don't know how it actually works in the real world. So any insight on that would be very helpful.
Well, I think we did have this discussion. I mean, where we got a lot of comments from our board members, and I know Patty was part of that conversation, because we were trying to come up with the right amount of hours, and I think that the board felt that limiting it to this amount and then giving them discretion in these other areas was appropriate at the time. So,
And I think there was something with ASHA that their hour requirements are different, but I think that the allowable of telesupervision was roughly half of their required hours. Any other questions, needed changes? Kelsey and I will work on the adding in the visual component into the definition. But if there's any other changes, let us know or make a motion.
Number 5 on, I don't know, last page. Do you need to say that, or you've already said about the 4 hours?
That at least 50% of the supervisor's direct supervision shall be of the RP temporary license holders' evaluation, assessment, and treatment procedures. I think here we're spelling out.
I think,
At
yeah.
That
least
as
part
opposed to therapy.
Right. Like at least half of it has to be
Well, it says
evaluating.
treatment.
Treatment.
Is treatment not therapy?
So this language is existing.
Yeah.
So
Beginning.
I don't know how the board came to that conclusion. we could definitely look it up, but this 50% in 5, the only thing that was added was adding the number 5 and then taking out supervisor's observation and putting direct supervision, and that's really only a consistency change because observation isn't really in here anywhere else.
it was kind of vague and wanted to be specific. This is what we're talking about, direct supervision.
Right, but again, if this is practically speaking, this is doesn't make sense to the board?
Well, it's already on top.
Well, okay, so what we're doing here is, these are regulations that already exist, and we were just being consistent because we called it direct monitoring, and then we called it supervisor's observation. We decided we were going to go with direct supervision, so in D we call it direct supervision, and in 5 we call it direct supervision. That's
Because
the only
we
change
also
we
added
had.
telesupervision, so we
Right.
wanted them to be consistent terms. So it was really for consistency's sake. It doesn't change any of the actual meaning.
I think she's wondering about the 50, are you wondering about the 50%?
Yeah, no, I hear that.
Right.
But what I'm saying is that's already in existence. So how the board came to that conclusion whenever they came to that
Maybe a
conclusion.
better question is, what is the other 50% observing? Administrative.
I think what it's saying is the quantity as a whole, that at least 50% needs to be this. Needs to consist of 1 and 2. I guess that was determined to be more important by a previous board. So they wanted to make sure that at least that quantity of that type of
But I think what I'm hearing
activity
is,
was monitored.
I mean,
Is
if-
that there's
if
no other
someone said,
activities to be
I
monitored?
spent- Okay, so 20% of the time I walked them to the bathroom, or I sat with them and felt while they filled out paperwork. I mean, there's not really a lot else.
so there's no, so.
So
what I'm
maybe there
hearing
was
is
an
there's
issue, maybe there was an
100%.
issue with people not observing those activities enough, and they wanted to make it a minimum, but.
But I don't know what else they would be observing, is my whole point.
Right, they're saying there's no other
Is it
activities to
necessary,
observe.
is it necessary that we even specify that then?
What's the participation in case conferences?
I almost feel like this is kind of getting to where you were in the beginning, like the
Yeah.
direct, I mean.
But she already said they could do it for 50% of the time and telesupervision as well.
So as long as it adds up to 8 hours at the end of every month.
Yeah, it's like everyone you watch, you have to watch at least 50% of one way or the other.
Right.
Yeah.
I just think, unless this is 50% of a session, I don't see where that is very relevant, to be honest, because it opens up.
It doesn't really make sense now that to me at least, being the layman. Because if you're saying you have to directly monitor and you have to do it for 8 hours, and you have to directly monitor for at least 50% of these activities, but those are the only activities, then like we said, what are you directly monitoring? Them filling out paperwork? And I don't know enough about sessions to know what other activities there could be, but if the board is saying that maybe we need to remove 5,
that would be my suggestion.
Or I thought we were saying that whether it's telesupervision or direct there, you could choose how long it is.
So yes, but it's all direct monitoring. So think of it as it's all direct monitoring, whether you're in the room or you're telesupervising.
Yeah, but you could choose how long you're going to, if it's an hour session, you could choose for 15 minutes, so long as your supervision added up to 8 hours a month.
Right, but
You
this,
could choose that.
but this is saying
That would not make it
50% of the 8
50%.
hours is how I read it. 50% of your 8 hours.
I think it should be 100% of your 8 hours.
Right.
Yeah,
So
it's saying
you
at
shouldn't
least,
be
right.
watching them fill out paperwork.
Right.
That's not direct
Right,
supervising.
that's not.
So
Direct patient contact or something like that, maybe you could put it that way. At least, or 100% of the supervisors' direct supervision shall be of the RPE temporary license holders' direct patient contact.
So I think that we do address that in the definition, because we say that direct supervision means in-person, real-time personal observation and guidance by the RP supervisor of activities related to the field for which licensure is sought.
That could still be paperwork.
Okay, so I think maybe we fix it there in the definition
Okay.
to define it to be maybe these 3 things: evaluation, assessment, and treatment procedures.
Yes, and then just remove 5. That makes sense to me.
And then I think it makes it crystal clear that if you're directly supervising, you are watching these 3 types of functions, right?
Well, but can I do number 3 and 4? Are those part of direct supervision too?
Yeah. Record keeping, evaluation, and assessment reports, correspondence, format summaries.
Is that,
You're
because
talking-
we
so you're
can't
talking
say
about
that and then call it,
reporting and,
right.
yeah. I see what you're saying.
So the 3 and 4 is kind of like paperwork.
Well, that would be their reporting, yeah.
And so another board probably said, well, at least 50%
Right.
of your observation has to be direct.
For the planning, okay.
And then, I don't know, do people have trouble doing record?
Oh, yeah.
Yeah.
I may not document correctly, or maybe too verbose, not enough
And
information.
they're having to switch from written to electronic
Yeah.
in the
So-
hospitals.
Yeah.
So
And
maybe-
a lot of times we spend time working on it.
Increase the percentage. If the concern is, you still want to make sure they're doing their record keeping right and whatnot, but maybe you don't need to do 50% of that. Maybe that can be 25% and 75% has to be this.
I don't know.
Well, would there ever be a scenario in which it would only be 50%?
I mean, I spend a lot of time with my students reviewing their.
But would there ever be a scenario in which those activities would only be 50% and the other activities would be what's in 3 and 4? Because it sounds like what a previous board was doing was addressing that not enough of those activities were being done, so they wanted to put a minimum there at least.
Yeah.
And so
Yes, I see exactly
I can
what
make
you're
a
saying.
bigger-
And when I look at it from 1 to 5,
Yeah,
it
it
makes
changes
more
it.
sense.
Yeah, it does, it does.
Yeah.
and you are directly
But honestly,
observing
if
paperwork?
I can call those other things direct supervision.
I could
I
see
can
where
make a bigger
record
case
keeping
for
needs to be observed.
participation in case
Yeah.
conferences, because how are you, when you're dealing with the group, when you're dealing with the family? I would, and I have.
And record
used
keeping is
4.
important to all healing arts
And-
licensees, that's always the issue. I mean, a lot of cases come down to record keeping.
Exactly. Exactly.
I think at the end, it would be like 25 number 1, 25 number 2, and 25 number 3, and 25 number 4. I don't know. But I mean, I don't want to put a number to any of this, but just like in general, like if somebody were to, monitor, it would be equal parts 1, 2, 3, and 4.
I think it's hard to kind of quantify it from that standpoint. I actually like the way that it's written now that I.
Yeah.
Well, and because also
Make a
there
case
could
against
be a
it.
case where you are supervising someone who maybe struggles in the record-keeping
Yeah.
part, but they really are excellent at every other piece. And
Right.
if you box yourself into, well, you need to focus on
Yeah.
these other things, even though they're not struggling in that area, it kind of gives you as a supervisor discretion
Flexibility,
where they need your help the
tailor it to
most.
each individual.
Yeah.
I'm throw another wrench in here. That is,
We got the whole time.
the university, our university, all of them that are ASHA certified, or ASHA accredited, will say that students can earn clinical clock hours under supervision for certain activities and not for others. And things like record keeping and report writing and so on, to my knowledge, don't count. I don't know if that, we have to care about that, but we're saying, okay, you supervisors, you have to be doing this, but the university that's giving this degree and monitoring that says, nah, you don't have to keep track of that.
But I want to come back to, Paul, the comment you just made. There's so many things that end up here are related to. Do
I
you
know,
know
but-
how
right.
to
So
do
if we
the
say-
record? Because this is not looking at ASHA, this is looking at what we do and what we end up with.
I understand, but if, I just think it's worth considering, if we say, okay, the supervisor can provide some of that 8 hours doing these things, but the students get no credit for it in terms of what they need to be supervised for.
They can do 1 through 3 100%.
Yeah.
All we're saying is that they must do at least 50%.
No, I get what you're saying, I'm just trying to.
So if ASHA doesn't give, right, so if ASHA doesn't give credit for any particular 3 or 4, then
So
they don't
basically-
have to do that.
Yeah.
That's true, no, the RPE is already out of the university, it doesn't
Right,
matter.
they're out.
So it doesn't matter.
Yeah, I mean, otherwise, I think you're just building a case for us to have more than 8 hours of direct supervision, because
Yeah, but I
I
think it's important to
right,
have
because the
that
interpretation,
knowledge.
test
Do you know how to do
interpretation
it?
is incredibly important. I mean, you can have an assistant perform the test, you need to be able to interpret the test that you've just completed and be able to write a cohesive report and
Right.
determine proper follow-up.
Would anybody care to know? And I'm the last person who wants to involve ASHA rules in anything we do. But I'd be curious to look at what they give clock hour credit for, just as an interesting thing to know. Like, we're saying you gotta supervise that, and the RP is saying, but the people who are gonna certify me don't care about that. Just so we'll know. I volunteer to go look it up and come back and tell you.
Thank you.
Thank you.
In my spare time.
Your spare time. True. I'm associated with the
So where are we going?
I think you're back to the original.
Yeah.
We're adding video.
So what I have is that to make sure that the language is consistent between the two types, that they are the exact same other than the sort of hours and additional things that you need to do in order to do telesupervision. But in terms of the direct monitoring, they are consistent. And then it's not the entirety of the session, but for whatever is counted towards that supervision has to be direct. And to add visual to the monitoring definitions and video monitoring to the telesupervision section.
So is there a motion? Oh, yeah.
When you guys do these, this is a question to the audiologist, when you guys do these therapy sessions and whatnot, it's usually at a hospital, right? It's never at some home.
schools.
It's not possible at schools.
Schools.
Okay. Throw a wrench in it. What if schools like this one doesn't have Wi-Fi? If you're in like a rural area and you want
I mean, that underlies this all. You know, if somebody doesn't have FaceTime, Skype, Zoom,
then it would
then
be.
you can't do it anyway.
Okay.
So they just, it'd be direct.
Direct
It would be direct.
Okay, so then it'll be the RP and then the monitor that comes. Okay.
Yeah.
So where are we?
Does anyone have a motion?
Is there maybe a motion to approve the language with the changes and to delegate to the executive officer to initiate the formal rulemaking and make any changes consistent with the policy set forth? I see a lot of nods, but not a
So
actual
moved.
motion.
Can I say so moved?
I don't know who's making it.
Nodding is not a motion.
So moved?
Okay, who was that?
Seconded?
Was that Karen?
No.
Oh, Marcia? Okay.
Who made the motion?
Marcia?
Who seconded?
I'll second.
Oh,
second.
They're all nodding over here.
All right, who did you wrote the second? So that my notes are consistent with yours. Okay.
Okay, it's been moved and seconded. Any further comments? Any comment?
I just kind of wonder what video supervision of report writing is. I mean, what does that even look like? You're Skyping someone while they're sitting there writing a report? That doesn't make any sense, right? I mean, with our report writing, if you're saying that that's part of what is allowed to be direct supervision, that just seems a little odd to me.
Maybe that's why they have 50%.
Right.
Well, 50% of the supervisors.
I mean, if you're gonna allow that to be part of the direct supervision.
And so where I work, we do audio reviews with our head and neck surgeons all the time where we'll either fax over or we'll send the report and we're like on the phone discussing the audiogram and
Right, but if
what
you're
their
including
recommendation would be.
visual,
But it could be a visual. I mean, they have a copy of it. Or a lot of times, the visual is already in their chart, so we're not really printing and scanning anymore. That was 3 years ago. But it would already be in the medical record, and we're there. But Kaiser also uses, I mean, we have video visits, and we use the video means quite well.
If nothing else, I would like to see it there, going back to Paul's point, so many things that end up here. Go back to, were the records well kept? Did they follow the criteria? And for that reason, it would not be a lot of time, but at least we know they're doing it the correct way.
And I think there is an aspect of professional judgment here. So if the supervisor doesn't feel that in their professional judgment that this is something that can be done via telesupervision, then it's not ripe for telesupervision, I think.
Like otoscopy, for example. We can't really, at least, no, I mean,
Oh, it's
I guess
just a matter of time.
there is some technology coming, but.
You don't like it either.
Any other discussion? Then let's vote.
Yes.
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 Okay. Motion passed.
Are we done? Are we done?
I know.
Oh, yeah, all right. Let's take a quick break.
Dee,
Yeah.
there is orange flavored water, natural fruit water back there for everybody.
Thank you.
So, one parent.
Okay, we're going to go into a part of tomorrow's agenda, and that's item number 3, the Executive Officer's Report. Included in your report, you have, in all of the 3 tabs, you have various reports from staff. I'll just go ahead and summarize and start in on some of the things that are going on in the board office. First off, I want to welcome, I realized when looking at my last report, I thought I had already introduced one of our new employees, Tanisha Graves, and I hadn't. So I want to take this opportunity to introduce all of you. I know some of you have already probably corresponded with her, but we're really pleased to have added to our staff Tanisha Graves. She is working as our enforcement coordinator. Tanisha came from the Department of Healthcare Services, right? And she worked in a lot of the administrative processes, some of the administrative procedures that we work with now. It's a little different on this side that we work with. She's going to be handling investigations, formal discipline, and probation monitoring. She's already gotten in, and you know, her first board meeting, she's going to have a petition hearing tomorrow. So she's being put right through the fire right in the beginning. Last month, the board hired another staff person, an office technician by the name of Kathy Cummings. She's actually starting in our board office tomorrow. And she comes to us from the federal government, has an extensive administrative, technical support background. She's going to be working as another person in reception, another person to help us with the phones and the mail, and another person that will help us kind of streamline our licensing workflow. If you recall, we added 2 positions through our budget change proposal a couple years back. But the budget process to add positions is usually 2 years in advance. So one of the positions brought us Heather Olivares, who you heard from today, and the other one is Kathy Cummings, who's starting tomorrow. So slowly but surely, we're trying to build our staff and be properly staffed to handle our workload. Included in your items is our budget reports. Those are behind item 3B. Our budget reporting right now is somewhat limited because of the state of California's conversion to a new database called Fiscal. So a lot of this is based on, you know, a lot of good budget reporting by our budget analyst, but some of these things may have to be reconciled later. We did want to include a budget report so you could see where we are as far as our spending, our projections. So the very first report behind 3B is our is our activity log that shows our expenditures. And the next page would be our revenue report. Our revenue is pretty much at what we would expect it to be. Our expenditures are low, meaning that we would revert more money, we would be more in the black at the end of the year. And one of the reasons for that is because of the vacancies that we've had. The vacancies that we've had have been in enforcement, and a lot of our expenditures have to do with enforcement. So if you have vacancies, cases are not being worked, and that would be reflected in this report. As we catch up, you're going to see more money being spent in the enforcement area. So right now, we're looking at about a reversion of 17% of our budget. It's usually in the 5% range, so you can kind of see where that is right now compared to what we usually have. Our licensing, we're actually getting ready to go into our what we call our peak season, and right now we're pretty caught up in licensing. We're doing a pretty good job. We've got, we're handling everything within about a week. Hearing aid dispensers applications are typically current. We usually get those done within a matter of days. Once a licensee passes the exam and they make that application, our licensing analyst in that area, Lisa Snelling, gets those done pretty quickly. The other applications are a little more involved, so I think it's really commendable that our licensing staff have been able to keep up with this workload and keep it, within a reasonable time frame. Our current time frames are at 1 week. I can't guarantee you that a few months from now they're going to be at 1 week. I'm going to guess that they're going to probably climb like they always do during that peak season. They'll probably climb a little to a lengthier period than they were last year because we do anticipate some staff turnover, and we're looking to hire someone else doing licensing. So we currently have one licensing vacancy, and we're looking to fill that. And I think, Brianne, we're close to filling that vacancy, right? That other licensing vacancy? Yes. Okay. Any questions so far on the licensing reports? Behind tab 3C, you have a summary of the statistics for licenses issued and our licensing population. So you can see that through the first 3 quarters, we're at about 3,000 licenses issued, and we've been at about 3,600 to 3,800 in the last couple years. So we're growing, but we're right on pace to where we should be. Back to my report on page 2, I wanted to give you some really good news, and I think this is something that our licensees are really going to appreciate, and that has to do with a project that we've been working on with Consumer Affairs OIS office, that stands for Office of Information Services. And the concept was because we are on the older database, what we call CAS, it's a legacy green screen database. We haven't gotten onto the new system. There's kind of benefits and drawbacks to not being on the new system, but overall we want to get on the new system so we can offer more services, online services. Well, we've been working on a project with them that would allow licensees to renew their license online. Anytime I go out and speak publicly to a group of licensees, this seems to be the #1 issue for them, the most important thing, to be able to not have to use an envelope and stamps and write checks, to just go online and renew their license. So we're actually really close to having that project completed. The OIS staff have been great. I want to commend Brianne Humphreys. She's kind of taken this bull by the horns and been working with them and got it moving and made it a priority. So we're really pleased to have this happening really soon. We're going to notify people. We're going to let people know anytime we go out, obviously, and speak publicly, we'll let them know. But we're also going to put out some notices. We're going to let people know in their license renewals when they get their notification that they can renew online. And the access to this online licensing is going to be on our website. There'll be a portal there that will allow them to do that. Any questions on online licensing? You would think that we would have had this done a long time ago, and I know that we're just kind of still in the 20th century, but we're very pleased to be there. We're very proud of this. Yes?
I have here, a hearing a dispenser practical exam.
Yes.
There is 41 hearing aid dispenser and 1 failed. And then there is 14 audiologists, 4 of them failed.
What are you looking at? Which one?
Moved on to 3D.
Okay.
Yeah, you see the practical exam.
So you're looking at January 26th?
Yeah.
Okay.
Oh, you have another one? I didn't look. Oh, sorry. If you have another one, it's changed the whole thing.
What Amnon is referring
what
to
I'm
is,
saying-
in your materials, we had 2 examinations that were held. One was actually held just this past weekend. We don't have the statistics for that yet, but this is for January and October, and that's behind tab 3D.
Yeah.
So Amnon, what was your question?
No, on this one that I looked, I didn't see even the other page. The other page gave a better result. That was showing that there was very minimal failure in hearing a dispenser and a little bit more an audiologist. I just want to say maybe we should exempt hearing aid dispenser from practical exam.
Okay, thank you for that comment. Are there any questions, are there any other questions on the practical exam? You know, one thing I did want to mention about the practical exam, we talked about the last meeting about conducting an examination in Southern California, and I think that I did explain that the cost of the exam is enough to cover the expenses of the exam. So the licensee's costs cover the expenses of the exam. We have in the past looked at some, different areas in Southern California. I think a couple years back, we did one in San Diego, and it turned out that it was very costly for the board to do it. So I think we're still, I wanted to let you know that we're still looking at options. Mm-hmm. Another option that we have is conducting examinations in our future office. So we're trying to build out examination rooms so that we can conduct ongoing examinations for people there in our Sacramento office.
There's no state facilities in Southern California that we can use? State, I'm talking state location.
I don't know that would not cost us money. Even using the Department of Consumer Affairs costs us money. So we actually have to pay for that. But in using...
so don't you pay for, what about Sacramento? Sacramento, you don't pay for it?
We do pay it. We pay a minimal cost. And because it's in Sacramento, it's less costly. But we'll continue to look into locations.
What's the most expensive part of that?
Yeah.
Well,
you had the same question.
Yeah. What's
Well,
what
one-
do you need and what's the most expensive?
So the expenses associated with the exam are the use of the facility, are the subject matter experts, which would somewhat cancel itself out because you have Southern California and Northern California experts, and then you have the staff. So our exam is staffed by our board staff. So I would have to move all those people to Southern California.
It's the entire office that participates too.
Right.
Okay. And then what type of facility do you need?
Well, we have to have a facility that accommodates examinations to be visually observed. I think we use a total of typically 24 examiners during the exam, so about 12 rooms.
Okay. And what Paul means by visually observation, that's windows, side windows into the little examination rooms where the senior examiner can observe as well.
Correct.
And it's hard finding those type of rooms.
We have 3 examinations that are still going to happen in 2019. One was just held, and another one coming in July, and another one coming in November. Any other questions on the practical exam?
Do these tables reflect how many times the person has taken the exam?
Let's see.
No, ma'am.
Okay. Curious about that.
We have statistics, I think, for previous years on people that have taken it more than once. I'd be more than happy to share that with you.
Interesting.
I have included in your board materials enforcement report, and this shows the number of complaints, the investigations that we're working. There are currently 10 formal discipline cases pending at the AG's office. That's lower than average. And we're monitoring about 35 probationers. Of the 35 probationers that we have, 8 of them require drug or alcohol testing, and 10 are in a told status. On page 3 of the report, you can see all of the disciplinary actions that have taken place in the last 12 months, the name of the licensee, and the actions that were taken. Are there any other questions regarding the executive officer report?
I thought you said you were going to split up the speech pathology and audiology complaints.
We committed to do that at the end of each fiscal year.
So you did it last July?
Yes.
Okay.
So in our next report, it'll be broken down.
It's not an easy report to get. It's not automated.
Oh, it's a hand count. Yeah, okay.
Yeah, as I mentioned earlier, we're in an older database. We use an older database, and we're in the process of converting. At the next board meeting, I'll probably have more specifics, but we call it the Business Modernization Project, where the conversion to what most of DCA calls BREEZE. The BREEZE system was done in 3 phases. The first 2 phases were complete. We're part of the 3rd phase. We have to go through the whole process of identifying, business requirements, of developing a database that works for our board. That's going to be very labor intensive, and it's going to definitely have an impact on our operations. And we plan on starting that this fall. Also out in the future, we're looking at moving to a new office, and that's probably more in line with the beginning of 2020. And we found a site and haven't completed everything in the process, but we're really close.
Going back to the budget
Yes.
for fiscal, the fiscal year is coming up. Are you guys anticipating trouble closing your books?
No, I don't think so.
Okay.
I mean, I'm sure that, well, I speak for us. I'm not doing the budget side. We have a budget office and the accounting office who work with that.
Okay.
I'm sure they have their challenges,
Okay.
but I don't think they're going to have a problem closing that.
Okay, so your office, actually, speech pathology, we don't do any of the accounting and budgeting?
No, well, we do limited. We do it from our side. We manage the budget, and we work with a budget analyst.
Okay.
And we work with accounting staff at DCA that handle all of that.
Got it, okay, all right.
A lot of the administrative functions that are done at a typical state department are done through the Department of Consumer Affairs. Like Brianne handles some human resources duties, but a lot of those things are also handled by the HR department at DCA, for example. Are there any other questions? Okay, that's all I have to you.
What would you like to do?
I think we can probably continue this tomorrow.
Okay, nice. All right. We're adjourned. See you in the morning.